So no more 30 days notice, 10 days notice, none of that. You got to let that subscriber go.
My faith rising. I'm crawling out the trenches, holding me. My life.
Hello, visionaries. Welcome back to my channel. My name is Maresa Talbert. I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. Over the past 10 years, we've seen the astronomical rise in subscription models for e-commerce and service-based businesses. We've seen this presented through your Netflix streaming services, through your Zoom conference call accounts, and even Amazon Prime. There's something quite attractive about the subscription model. One is the allure of recurring revenue for the service provider, and the other is the convenience and predictability for the consumer. What often ends up happening with subscriptions is that you provide your credit card information, and that credit card is charged every term, whether it's monthly, quarterly, or even annually. And these subscriptions never end unless you intentionally cancel your subscription. So you might even forget that you're paying the subscription fee, even if you're no longer using the services. While this may be ideal for an e-commerce business or a service provider, newsflash, if you're a California-based business or service provider, or you market your services to California residents, you better think again, because you could be breaking the law. California has some very specific rules related to the use of automatic renewals for business. So I'm here to keep you out of trouble. In this video, I'm going to share with you 6 ways that your automatic renewal clauses might be breaking the law. Let's jump right into it. Number 1. You don't have clear and visible offer terms. If you offer a subscription plan, you must disclose to the subscriber in a very clear and visible manner that the subscription will continue until it is canceled. This could be completed with a confirmation email or even a letter to the subscriber explaining the following. As I previously mentioned, that renewal will continue to occur until it is canceled by the subscriber, the length of any additional terms, such as another 30 days or another 12 months, how the consumer may cancel, and any other terms and conditions that may apply to the subscription plan or the renewal. You'd want to ensure that any language that is intended to satisfy this requirement is larger than the surrounding text, or has some type of contrast, such as font or a color contrast to the surrounding text of the same size. Basically, you need to put this language in all caps, bold it, italicize it, underline it, do whatever you need to do to call attention to this language. More specifically, if you are a service provider, you must inform the subscriber of any alternative offers that are not subscription-based. For example, I offer subscription plans to my clients. However, I cannot only tell potential clients about the subscriptions. I have to tell them about all of my other services that they could partake in. Additionally, if you offer a free gift or a free trial of any kind, you must also inform that consumer on how to cancel and allow them to cancel before any goods or services are purchased. Number 2. You don't have affirmative consent to the automatic renewal agreement. The term affirmative consent sounds really legal, but it doesn't require you to do any extraneous actions. The court has already determined that affirmative consent is met when a consumer signs the agreement with the automatic renewal terms. If you wanted to take it a step further, you could always add some language to the effect of, by submitting your order or by signing this agreement, you agree to the terms and conditions of this agreement. Just my little 2 cents. But the court has not required any separate explicit consent. Number 3, You don't provide any acknowledgement after a subscriber has purchased a subscription. This requirement kind of seems like, duh, this wasn't already happening. But how many times have you signed a contract and you never received a copy afterwards? Give me a hand raise emoji in the comments if you've ever signed a contract and you never received a copy afterwards. Well, California is not having it. Once a consumer subscribes to your subscription plan, you must provide them a copy of the terms and conditions. And those terms and conditions must include the automatic renewal policy and the cancellation policy. Number 4, you don't have an immediate cancellation option. Okay, listen closely. If you provide access to your subscription plan online, then you must also provide access to cancel exclusively and immediately online. So no more 30 days notice, 10 days notice, none of that. No, call this number, none of that. You got to let that subscriber go. Now, this type of cancellation may include a requirement to terminate by email, but the email must be pre-formatted and provided by the business so that the consumer can cancel with ease and doesn't need to provide any additional information. You got that? Number 5, you don't provide notice when there are material changes to your terms. If you significantly change the terms of either your automatic renewal terms or your subscription model after it has already been accepted by a California consumer, you have to provide notice in a clear and visible manner of the changes that were made. And don't forget, you have to provide information on how they can cancel before those changes take effect. And number 6, you don't send reminder notices to your subscribers of their upcoming renewal. Let me say it again for the people in the back. You don't send reminder notices to your subscribers of their upcoming renewal. If you offer automatic renewal subscription plans with an initial term of 1 year or longer, you must provide a reminder notice that renewal is coming back up at least 15 but no more than 45 days from the time that the renewal should take place. And you have to remind them that their subscription plan will automatically renew unless it is canceled. On the other hand, if you offer a free trial, a free gift, or a promotional price, you must send your subscribers a reminder notice at least 3 but not more than 21 days before their trial, gift, or promotional price expires, informing them that it's coming up on the expiration date. Does that make sense? So let's quickly recap. If you are an individual or a business that offers subscription plans with automatic renewal terms,
because why have a subscription model if it's not going to continue seamlessly?
then there are some legal requirements that you must adhere to. Number 1, you must ensure that you have clear and visible offer terms. That means get your contracts in order. Yep, that's what that means. Number 2, you must ensure that you have affirmative consent for automatic renewals, which refers back to number 1. So get your contracts in order. That's what that means. Number 3, you must provide acknowledgement of the consumer's purchase of a subscription plan, which basically means giving them a copy of the contract. Did I say get your contracts in order? Yep, get your contracts in order. Number 4, you must provide an immediate cancellation option. No delay. And for most subscription plans that are offered online, you must provide the consumer with the option to cancel online. Number 5, You must notify your subscriber of any changes to their subscription plan. And number 6, you better remind that subscriber that their subscription is about to renew or that their free trial, free gift, or promotional price is about to expire. I just want to reinforce that these requirements apply to California sellers, businesses, and consumers. And these requirements went into effect July 1st, 2022. If you need help ensuring that your business and your subscription model is in compliance with these new requirements, go ahead and click down below to schedule a consultation with Talbert Law Office. I hope this video was helpful. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video.
I done made it this far. I'ma keep it pushing, yeah. Even made it through the